Yes, good morning, Mr. Edinburgh. I've just got to make sure that my wonderful new all-singing, all-dancing screen arrangement is working. And
full screen, yes.
yeah, no, it seems all right.
Good.
Right, on you go.
My lord. My lords, I and my learned junior, Thomas and Quinton, appear for the claimants in this matter, who are the appellants, and my learned friends, Mr. Alexander, one of Her Majesty's Counsel, and Mr. Kay, appear for the defendants, who are the respondents in this matter. I trust that your lordships have received the core and supplementary bundles and the authorities bundles, both in hard and soft copy, as is convenient for your lordships.
Yes, I think we have.
My lord, there was a debate, a flurry of emails with respect to further authorities and what have you. The long and the short of all that is we can provide whatever authorities you like, in whatever format you like, whenever you would like. But I was alive to the issue of the practice note with respect to 10 authorities, and I endeavoured to keep to that. Strictly,
Well, I'm
we're
very
still within.
pleased you were, Mr. Edinburgh. It may be that Lord Justice Arnold is more enthusiastic about authorities, but we will see how relevant they all are as the case progresses.
My lord. As you'll be aware, the trial of this matter occurred before the Honourable Mr. Justice Michael Green in December 2020, and save for a small matter, in essence, the claimants lost on pretty much every ground. So when we sought permission to appeal, there were a number of grounds, 7, and the judge granted permission to appeal on all 7 grounds. There is no respondent's notice. The grounds of appeal, in essence, fall into 3 distinct groups. Grounds 1 to 3 relate to the use of the sign in the United Kingdom, the various aspects to that. Grounds 4 to 6 concern the role of D3, that's Amazon.com, and ground 7 is a freestanding ground which relates to the issue of the inquiry as to damages. To give you an indication of how I intend to proceed, subject to your lordship's interventions, I was going to give a very quick introduction to the background of the matter so as to lay out the groundwork. It's then necessary in my submission to address a number of myths that have arisen in this case, both within the judgment and also within the defendant's skeleton that's before your lordships.
Myths?
My lord, yes.
Right.
I'll explain those as I touch upon them. And then I was going to give a very brief introduction to the framework of trademark infringement as a whole. The reason for that is because if I do it in one place, I then don't have to come back to it piecemeal with respect to each and every time it arises. And it gives, so to speak, an overall view for your lordships.
Have you agreed a timetable with Mr. Alexander?
No, my lord, but we're down for 2 days.
We are, but I was hoping it might take less, Mr. Edinburgh. What about that?
My lord, I envisage it will take more than a day, but I could see us finish in...
I'll give you that.
My
But,
lord.
how long are you going to be?
In opening, I was going to be approximately 3 to 4 hours, so take you beyond lunch.
Right.
But leaving my learned friends...
And that includes your tour d'horizon of the law of trademarks.
my lord, that will be brief, but yes. And then my learned friends...
a lot of this case is quite academic, isn't it, since it involves $2,000?
My lord, yes and no. It is true that the total number of sales was registered in the low thousands of US dollars, but it is not academic in a number of important aspects. With respect to this case in particular, it's important with respect to what the defendants can and cannot do going forward. and it has
I
wider...
thought the defendants had agreed what they weren't going to do going forward.
Yes, but they have only indicated what they will do or not do going forward. There is no binding constraint upon them, my lord.
Well, you're not seeking an injunction.
My lord, to be blunt, that will depend upon how your lordship's judgment unfolds.
Well, where's the application for an injunction before us? I haven't seen one.
Well, my lord, it will fall under...
Is there one?
Well,
It's in the claim form, isn't it?
Is there?
my lord, yes.
So you want an injunction from us?
My lord, it depends upon how your lordship's judgment unfolds. So I have to reserve my position on that.
Despite the fact they've agreed not to do what you asked them not to do.
If you look at the wording of the order, my lord, it's an intention not to do something.
I mean, you know, you're going to receive judicial resistance if you want to turn this into a state trial about something that doesn't really matter, Mr. Edinburgh.
Well, my lord, I understand that.
Yes, good. Well, I'm pleased you do understand it. I mean, I quite understand targeting. I quite understand your appeal on targeting. It does seem to be an appeal. It's a proper appeal, a proper argument. But the question of the further ramifications of the Blondquist case seem to me at the moment to be slightly overblown, shall we say.
Well, my lord, I can see why you might think that at this stage, but
Yes,
it's my
will
job
you try and persuade me that I'm wrong?
My lord, yes. And actually, with that indication, my lord, it was going to be that the first ground, which is the targeting ground, was going to form the substance of my opening. And it's actually then a cascade pretty much in time and effort with respect to the other grounds, so as to give you some indication of how much more you have to listen to me, my lord.
I've no objection to listening to you at all, Mr. Edinburgh.
My
It's
lord.
just that the thing that I balk at is being asked to decide an academic point about $2,000. I made the point already.
My lord, yes, I have that firmly in mind.
Yes.
My lord, with that, I was going to give you a very brief background. It is going to be brief. The claimants are the proprietors of certain trademarks in the Beverly Hills Polo Club brand, and the second claimant is the exclusive licensee. You'll have noticed that this brand is split globally, such that the claimants have, inter alia, the UK and EU rights, whereas an unrelated party has the US rights. That does turn up in a number of aspects in the judgment.
I mean, they're not unrelated parties. They're brothers, aren't they?
Well, they're brothers in...
Yeah.
Yes, sorry. They're related by blood, but they're unrelated with respect to commerce, and that's the important point.
Yeah, I also understand that.
My lord. The defendants are three of the companies that form part of the Amazon group. There's over 2,000 of those companies within that group.
So you said 3, but I count
So-
5.
I'm sorry, my lord, did I say three? My apologies. 5, my apologies. 5 of the
There are
defendants.
2,000 companies, are there, all incorporated in different jurisdictions in which they trade, or what?
It's a worldwide network. It's approximately 2,370 odd. We're talking about 4 different business models here. The first of which is global, which is whereby the .com website is viewed by a local website, in this case .co.uk. The second model is the export model, which is where you go directly on .com. And then there's a model which is called fulfilled by Amazon, whereby Amazon does not sell the relevant goods, but everything else is done by Amazon. And then there's fulfilled by merchant, which is where the goods are sold by the merchant, and some of the fulfillment services are done by the merchant and others are done by Amazon. The original allegation related to trademark infringement and passing off, and also invoked both UK and EU trademarks. Nothing turns on the difference between UK and EU trademark law, but I will broadly refer to the EU position because most of the cases are EU cases, and so therefore it means it's easier to understand which article you're referring to. Also, there's two simplifications. The first of which is that the way in which it was pleaded originally invoked not only the double identity for trademark infringement, but two other types of potential trademark infringement. In the end, there was no need to rely upon those other types, and so therefore they go by the wayside. Similarly, passing off was also alleged originally, but again, there was no need to rely upon that when the facts turned out. So therefore, that goes by the wayside. As is typical with an IP case, there was a split on liability and quantum, so therefore the trial was concerned with liability only, and quantum would have been hived off to a separate inquiry or an account. On the 30th of November 2020, there was a very limited admission that namely D2 and D4 produced adverts that would infringe, and that related to the use of those signs upon the global business model. You'll have noticed that there was a request in essence for an Article 267 reference very late in the day. The judge held that he wasn't going to do that, and that reference related to the Blondquist case.
Why did he hold that?
The judge?
Why, yes.
The long and the short of it is...
It was asked for by Mr. Miller, right?
My lord, correct.
Yes.
The long and short of it was asked very late in the day.
Right, it was just before the EU, just before the UK's departure from the EU, was it?
Correct.
And that was the reason?
Yes,
I mean, it's in the judgment.
It's in the judgment.
Yeah.
I can take you to it if you like.
No need to take me to it, but it was basically because it was too late.
The judge thought that in order for a reference to get off the ground and to be properly constituted, he would need to produce a judgment in short order.
Oh, right, okay.
That's not actually necessarily so. It is possible to send a reference without a judgment. You just have to agree the questions.
Did you oppose it?
We did.
Right. So you must remember the grounds on which you opposed it.
We opposed it on the grounds it was basically inappropriate. It was unnecessary, because we said the law was clear.
You said the law was clear, yes, okay.
The judge found the law was clear, but not in the way in which we considered it to be.
Mm-hmm. Okay.
And as your lordship has already pointed out, there was no injunction, and that was predicated upon the fact that the defendants had no intention of removing the restrictions that are in place. So, now touching upon the 5 myths that I say that this case concerns and which are important to dispel at the outset. The first myth is that this case concerns mere visibility, and the emphasis is upon the word mere. We say that is wrong. We say that the claimants are concerned with use of infringing signs in the UK or EU, and that includes use in the UK and EU by means of adverts and offering or exposing for sale, import or sale of infringing goods, and that the reason why the use with respect to adverts, exposure and offering for sale is important is because we say it has an effect upon the commercial viability of the way in which the claimants can operate when they try and secure their licensees in Europe. And so even though now, because of the restrictions, you cannot ship to the EU or UK, there is still some visibility with respect to what we say are infringing adverts and offers and exposure for sale. At one point, the defendants have said that our case, that is the claimant's case, is actually trying to remove any need or requirement for targeting. My submission, that is a false target in the sense that...
Is this your second myth?
My point, yes, my lord. We actually say that there is a need, a critical need for use within the UK and EU. And it is that use within the EU, UK that secures jurisdiction of this court. So we're not trying to remove that. The absolute opposite. We say it is necessary and that it happens in this case. The third myth concerns the allegation that what we're concerned with is the censorship of the internet, because we're trying to stop the publication of information about prices of US branded BHPC, Beverly Hills Polo Club, merchandise that is available for sale in the US to US citizens. We're not trying to censor the dissemination of that information, that price information, but we say that the fault lies in the fact that that information is not coupled with the critical piece of information that such goods are not available in this jurisdiction. By that I mean the UK or EU, because this case was of course held before implementation date of the 31st of December 2020. A sort of sub-aspect of that third point is that the judge, in paragraph 48 of his judgment, in essence accused the claimants of hypocrisy because they didn't see the irony of the fact that some of their activities concerned what he said was the reverse situation, namely that EU-branded Beverly Hills Polo Club merchandise was available in the US. Well, we say that that is a bad point. There's a number of reasons, but the simplest of which is that it doesn't destroy the market of the US merchandisers, because of course the UK price is that much higher. So any US customer seeing an EU price will think that they're getting a bargain.
But what's the price got to do with trademarks?
Well, the judge was concerned about the issue because there is a price differential between the US branded products and the UK branded.
I know there is. I mean, of course we wouldn't be here if there weren't. But you could change the price at any time you want. So what has price got to do with whether there is formally an infringement of the trademarks?
Because the price is one of the things that is under the control, in essence, of the trademark proprietor, the way in which they present their brand on the market.
Where does it say in the legislation that it depends on price whether there's an infringement?
It doesn't with respect to that.
No.
What it does say is it's one of the functions of the trademark.
One of the...
It's in essence one of the protectable functions, the aura that surrounds the trademark. And part of that aura is encapsulated in the market position that the products occupy. So, for example, my lord, if you were to buy a perfume from any street salesperson at a low price, it's unlikely that you would consider that that perfume has a high repute or a high attractive power, in contrast to buying, for example, Chanel whatever, which is positioned in a completely different part of the market.
I mean, I understand all about markets, Mr. Edinburgh, but what at the moment I don't understand is what paragraph 48 and the accusation of hypocrisy has got to do with anything on this appeal, except playing to a gallery.
Well, no, my lord, in the sense that the part of the justification that the judge seemed to invoke was that it was part of the claimant's case that they were trying to censor the internet. And we're trying to say that that's not our case. So that actually leads to the fourth point, and that is that the consequences of what's happened in this case are basically just part of the rough and tumble of the way in which the internet now works. And so therefore, because the internet has global reach, one should in essence be allowed to ride roughshod over territorial local trademark rights. We say actually that the internet needs to respect territorial trademark rights, and that one of the consequences of that is that if you have a site located in another jurisdiction, then it still needs to act in a manner that's in accordance with the local trademark law. And then the fifth point is that this case is unimportant because the matter concerns small sums of money. This touches upon a point that my Lord has already raised. We say that's completely wrong. IP cases often proceed on a basis of test or trap purchases. For example, the Blondquist case itself concerned a watch that was bought for a few $100 US. The Cartier case, which is another case in the bundle, concerned one bracelet. And the Coty case concerned only a few thousand US of perfume. What we say is important is that a claimant that has had their trademark rights infringed has the right to have them protected, and that there is no exception for exploitation by a large company, and there should be no exception for only small-scale infringements. It's still a matter of principle that needs to be addressed. Then, if I may, I was going to move to an outline of the scheme for trademark infringement. And this can be taken up in the authorities bundle. Tab 11. Tab 11, we have Article 9 of the EU trademark regulation, and at tab 12 we have the UK version, which is the implementation of the related directive. So, the first point is Article 9, paragraph 1. The registration of an EU trademark shall confer on the proprietor exclusive rights. That's where we get the monopoly rights up and running. Paragraph 2, the point being is that you can stop use of an allegedly infringing sign if there's no consent. That use must be use in the course of trade, so that's where you get that requirement. Article 9.2a is the situation where the sign is identical with the EU trademark and the goods and services are identical. So that's the double identity requirement. You don't need anything more, there's a caveat to that, but it's not relevant in this situation, than double identity. Article 9.2b and c are not relevant now for this case. And then Article 9.3, the following in particular may be prohibited under paragraph 2. The first point there is that in particular, we say, shows that the following is a non-exhaustive list of examples. Then turning the page, you get the first 9.3a is affixing the sign to the goods, but paragraph B, offering the goods, putting them on the market, or stocking them for those purposes under the sign would be an infringing act. It's important to note that offering the goods is different from putting them on the market. Then in paragraph C, you have importing the goods under the sign, and in paragraph E, using the sign on business papers and in advertising. The wording...
What does under the sign mean in the context of importing?
In this context, my lord, it means that if you have goods that are marked, so clothing bearing the BHPC trademark, and you import those goods, then that is importing the goods under the sign.
What if you're an individual who buys goods in America in a shop and then sends them, and then somebody else sends them for you to the UK? Is that importing under a sign? What's it got to do with the sign?
The answer to your question is yes, it is importing, and it's under the sign.
Well, I know it's importing, but is it importing under the sign?
I was just about to address that, my lord. It is under the sign because the goods bear the sign. So
this applies to all individuals who. So if I go to America and I buy, I don't know, proprietary branded trademarked goods, and I buy a suitcase full of clothes for myself from Macy's or wherever I might go in New York, I bring them back in my suitcase, I can be accused, can I, of importing these goods under the sign?
no, my lord, because in that particular factual matrix, you don't comply with the requirement in paragraph 9.2, using in the course of trade.
Okay, well, what if I buy them for my friend to whom I'm selling them, having bought them in the shop?
Then you are
I'm
acting...
importing under the sign, am I?
Yes, my lord.
It's remarkable.
Well, it is. That's the way it is, my lord.
Doesn't matter whether sales got nothing to do with it.
That's correct, my lord. These are separate, distinct potential acts. And so therefore, if you look at the entire journey for a commercial transaction, there'll be separate wrongs. So for example, you might advertise something, that's a wrong. You might put it on the market, that's a separate wrong.
But what I'm with the first question I asked you, I mean, I get all that.
My lord.
Mr. Edinburgh, I've actually done a trademark case before, you'll be amazed.
Yeah, I know.
But the point is that the under the sign must qualify importing. And what I'm asking about is your submission seems to mean that any importing of the goods at any cross-national exporting or importing is done under the sign because there is a sign on the goods, not because of a sale that may have taken place years before or years afterwards. What I find odd is just the act of importing goods on which the sign exists is importing under the sign.
Well, my lord, yes, it's a separate act. It's a separate wrong.
Right, so any cross-national importation, even if it's not directly connected with a sale or succeeds a sale, is covered. It's very wide.
Yes.
Okay.
It goes further, in fact, because the sign doesn't need to be on the goods, it could be on the accompanying invoice.
Yes, my lord. I mean, the
In
way
nearly any circumstances.
well, the way in which my Lord Justice Arnold has just expressed it is that, point being, I was dealing with the narrowest possible way, that you have good bearing the sign.
Well,
But it can be wider.
No,
my
but
lord
of
has
course
just
it can be
explained.
wider, but I'm talking about this case.
Yes.
Yeah. You say anyways, if they cross national boundaries, that's it.
Well, the importation also has another requirement, and that is it must have cleared customs. That's the critical point about importation.
Well, of course.
Because once you've cleared customs, it is then possible for those goods to go into free circulation.
Yeah, and there's a lot of CJU case law on that.
The critical limiting factor is use in the course of trade, I think, in these examples.
My
Because
lord, yes.
every time I go on holiday with my suitcase full of branded goods, I am exporting or importing, depending whether I'm going or coming back, goods under the sign.
Yes, my lord.
And the limiting factor you're pointing out is in the wording that it has to be in the course of trade, because otherwise everybody is doing it all the time.
Yes, because you are acting in a personal capacity when you fly abroad and fly home. So therefore the goods contained within your lordship's suitcase in essence aren't infringing goods because you're not acting in the course of trade.
Yeah, but the point my lord was putting to you is that that's all independent of whether there's been a sale.
Yes.
In other words, I've owned my branded goods for ages. I keep coming and going with them. It's completely independent of the sale. But it's because I'm on holiday, not doing it in the course of trade, I think is the, as I understand it.
There's another complication, and that is the rights might have been exhausted. So we're talking here where the rights have not been exhausted. The long and short of all that is that once the goods are being properly put on the market with the consent of the trademark proprietor, and the trademark proprietor exhausts their rights, and that means, in essence, they can't control downstream activities.
Yeah, but then you get into the fact we have regional exhaustion, not international exhaustion.
Yeah, I was simply following my lord's example of the first time I buy a branded goods on holiday in New York, I fly back to the UK. You say I am indeed importing under the sign, but not in the course of trade, just for my personal use.
My lord, yes.
And next time I fly out, let's say to, I don't know, choose a European capital, but go somewhere else with the same piece of clothing, I'm exporting under the sign, but not in the course of trade.
Yes.
No, but when I ask my lord to go to when I say, oh, you're going to New York, I say, Lord Justice Snowden, could you get me a branded good and bring it back because it's cheaper over there? And he does. And even if he brings it back and later sells it to me, you still say that's an infringement.
My lord, fortunately, when you used the quote mark, that is a critical distinction. If he were to give it to you as a gift...
No, of course,
but if
that's
were
not in the course of trade. But if he's doing it for me as a trading transaction, in other words, he is actually selling it to me at the price he bought it,
or even a markup, yes,
or
exactly.
even a markup, then it's in the, you say, in the course of trade, and there we are.
Yes.
And the whole, anyway, where we started with all this is the word under the sign, which
yes,
you say is very broad.
Yes.
Yeah.
You'll have noticed from the judgment that the judge at first instance raised the point that sale is not expressly mentioned within the prohibited acts. He thought that was odd. Well, the first answer to that is that these are just examples and there's a non-limiting list. But the next point is that a sale is often actually putting on the market. So if the trademark proprietor sells something, then that is putting those goods on the market. There's a small point with respect to offering the goods, and that is that this must be a European concept. And so we say that it most likely includes an invitation to treat. The reason I raise this is because it was raised by the defendants at first instance. But it doesn't really matter whether it includes it or not, because this is a non-limiting list. If offering the goods does not include an invitation to treat under UK law, then one would be able to capture an invitation to treat just as another example that's not expressly limited. You'll have seen, therefore, from what I've said already, that putting on the market is not the same as importing. they're listed separately and they refer to different things. Importation requires the clearance of customs, and once they are cleared, you then have those goods in free circulation. Putting on the market, in essence, is the transfer of title from the trademark proprietor to a third party who then has the right to dispose of those goods. And that transfer of title does not need to take place. No, I'll stop there. So, touching once more upon importation.
I'm a little puzzled by that submission.
Sorry,
Is
my
there
lord.
any authority that establishes that putting on the market requires a transfer of title to a third party?
I think Class International might deal with that, my lord.
Come back to it later if you will.
Yes, I'm sorry. It's not there. It's probably going to be in top logistics. We've already touched upon it, but with respect to importation, there's no need for the importer to have title to the goods, so you can be importing third parties' goods, and that would still fall within the scope of importation.
Well, that's as intuitive as it is counterintuitive to say that the words putting on the market mean there has to be a transfer of title.
Actually, sorry, my lord, Master of Rolls, I've actually just found the relevant reference for my lord, Lord Justice Arnold. It's in Peak Holdings, paragraph 39.
So in which?
Peak Holdings.
Pete?
Peak.
Peak.
Peak, as in summit, mountain.
Yes. Is that it? That's in...
Well, no. That's in...
Don't worry, that's sufficient for my purposes.
Right. It's paragraph 39, my lord, you've got that.
And what's the basis of it? Since it sounds, as I say, counterintuitive.
I'm terribly sorry, my lord.
What is the basis of that reasoning? Because it sounds counterintuitive to me, I'm sorry, but putting on the market sounds the very antithesis of transferring title.
Well, the point being is that if you have transferred title from the trademark proprietor...
if you have transferred the title, you may well have put on the market, but I'm suggesting that putting on the market doesn't necessarily entail transferring title, which is what you're saying.
No, my lord, I'm sorry, I was trying to say it the other way around.
Oh, okay.
It is an example of...
It's not an issue.
So you would accept the point my lord was putting to you, namely it may go wider.
Yes, my lord, sorry.
It's bound to get wider.
Yes, sorry, I think
Okay, well, we cross
I've misunderstood.
It's fine.
If you're going to move off importation, can I just ask a similar question? If we have a chap who goes into a shop in New York, buys something, a branded goods, and instead of taking it back to the UK in his suitcase, asks the shop to ship it back to the UK for him, leaving it to the shop to arrange how that occurs, which courier, etc. Who's the importer in that scenario?
Well, there might be a number of people who claim to be the importer, but critically, the commercial agent, the commercial trader that is doing the importing, the courier, would be the importer who's acting in the course of business. Their business being importation business.
The consignor.
My lord, yes. Much shorter answer than my answer, my lord.
Yeah.
But it may depend on the contract of carriage.
Well, in any event, the person who's actually doing the importation is the importer, commercial courier.
But it wouldn't be the shop.
The shop is not directly doing the importing, no. But they might be liable in other ways. But that they are not the importer in that sense.
Yeah.
Does that answer my lordship's
Yes, sir.
question? Anyway, the way in which this discussion has turned out is you can see, of course, that the critical touchstone is that contained within 9.2, namely that the act about which one is talking has to be use in the course of trade. And that, of course, says that it's not a personal thing, and you have to construe the word use, and that is the word that's contained within the legislation. And that actually then brings me, in essence, to the first ground of appeal, because that use obviously has to be within a jurisdiction where the claimant, the trademark proprietor, has rights. And so the first ground of appeal touches upon this point of...
Well, sorry to interrupt, Mr. Reaver. Can we just be clear as to where we're going here? The subject of use in the context of trademarks is a subject on which whole books have been written and reams of academic articles. But are we actually concerned with use? Or are we concerned with in the course of trade?
In my submission, it's mainly the former, not the latter, for the following reason. Use must be use within the jurisdiction in order to fall within the potential exclusive rights of the trademark proprietor. And the reason why the in the course of trade is a subsidiary issue is because we say that it's fairly obvious that all the actors in this case are acting in the course of trade. This is not a case, we would say, of a person unilaterally bringing back goods within their hand luggage.
Okay, I understand that question, that answer, but can I refine my question? So, if we're looking at use, the question, as I think you just said, is not really about whether it's use or not use. The question is it use within the relevant territory?
Yes, my lord.
Yeah.
Because there's no real question about the acts, be it advertisement, be it importation, or whatever.
Yeah.
Lord. So, we say that the critical thing is to construe the word use in the context of the legislation, whereby that use must be in the relevant jurisdiction. And we say that, unfortunately, the use of the term targeting has really misled people. So, this has a number of strands, the first of which is as follows, is that if you have a website, then we say that it may use trademarks in more than one jurisdiction. We don't say that that's a very contentious proposition. And various references to that will be found in our Court of Appeal skeleton at paragraph 21. But at this stage, it's important to note that it is not the claimant's case that we are saying that .com targets the whole world. We don't need to say that. But we also say...
Well, you're now using the word target. I thought target was misleading.
Well, my lord, sorry, I was everybody uses it as a shorthand.
Well, I mean, I want to know what's wrong with target.
Well,
what's
because
misleading? What's, you know, if you're criticising the basic terminology that's been used in
my lord,
loads of cases, you need to tell us what terminology is preferable and why.
The preferable terminology is use in the relevant jurisdiction. We say there is no requirement that a website must use the relevant sign in one country uniquely. And we also say that it is possible for more than one website from the same organization to use the same sign in the same country.
I mean, that's obviously possible.
Well, we say in this case it's particularly relevant because some of the judge's reasoning seemed to be predicated upon the fact that because the .com site used signs in the US, it could not therefore use those same signs in the EU, UK.
But what I'm troubled about is that you premise all this by saying you don't say that .com targets the whole world. Why not? It obviously does if the rest of what you say is right.
Well, there's two answers to that. The first of which is I don't need to go that far. I only need to say...
Well, but it's the conclusion of what you're saying. I mean, I understand you don't need to go that far, of course, but the argument against you is because it's the conclusion of your argument is wrong.
Well,
so
no,
you need
my
to
lord.
explain why it's
because
why it's not your argument.
There is no evidence to show that .com targets, using the wrong word, but uses a sign in every jurisdiction in the world, of which there's about 200.
But it's accessible from every jurisdiction in the world.
My lord, yes. That's a completely different point. Mere accessibility, we've never said, amounts to use in the relevant sense.
So what are the components of use in the relevant sense?
I was going to come to that, my lord. So, if I can take you to in the authorities bundle, tab 10, you have the Argos case in the Court of Appeal. Paragraph 48.
You have a page.
Page is 339.
Thank you.
here we have, targeting is not an independent doctrine of trademark law. It is, in essence, a jurisdictional requirement. Because trademarks are territorial in effect, those who are doing business exclusively outside the UK should not have their dealings subjected to the trademark law of the UK. Failure to recognise this principle is a failure to give effect to the territoriality of the underlying rights. Moreover, the fact that a website is accessible from anywhere in the world and may therefore may attract occasional interest from consumers there when this is not intended should not give rise to any form of liability. So the point there is that mere accessibility from any of the 200 odd jurisdictions within the world is not sufficient to give rise to liability, because the courts don't claim any jurisdiction over such use. But if there is business within a particular jurisdiction, then that jurisdiction can claim a claim over the allegedly infringing use.
But I mean, if taking Amazon as an example, you go on Amazon.com and you show interest in a good, and they say, what's your name? And you say Smith, and then they say, where do you live? And they bring up a drop-down menu of every country in the world, right, which is possible because they're shipping to every country in the world. Then it's not just accessible to those countries, it actually allows the people from those countries to buy. So why is that not use in the relevant sense?
Well, the way in which your Lordship's question is going is that it would be use in the relevant sense because they are doing business within that jurisdiction.
Right. So it is in fact not targeting but use in the relevant sense over the whole world.
Well, again, I don't have to go that far.
But if the drop-down menu covers every country, then that's that.
Well, it is perfectly conceivable that a site does intend to do business in every jurisdiction in the world. Whether on the facts it does is a separate issue.
It makes it quite difficult for people to do business globally, which a lot of business is done now globally.
Well, in reality, actually, very few traders trade everywhere. Very few.
That's true.
And one of the pieces...
Everywhere's a long way.
Well, one of the pieces of evidence for that is very few entities have trademarks registered in every jurisdiction. When somebody says they trade internationally, they commonly trade in 20, 30, 40 countries.
Is it common for trademark rights to be bifurcated in the way in this case?
The judge held no.
I know what the judge held, but I'm asking whether
On the basis of what evidence?
On the basis of some cross-examination, my lord. That was it.
What's your case?
Well, to answer your question, I have to give evidence, my lord, but in my submission...
But do you have a case on it, or do you say that you haven't appealed what the judge found?
We have not appealed that finding of fact because we don't need to.
Right.
It's quite commonly the situation that people register trademarks only in certain jurisdictions and not in others.
Yes, my lord.
I mean, we're talking about bifurcating trademarks, but a very common situation is where there just is no trademark protection in certain jurisdictions.
That's by far the commonest situation.
Sorry. Can you enlighten me on this? How could the judge make a finding of fact on factual questions that were not before him? The truth of the matter is that it is absolutely commonplace for trademarks to be in different ownership in different countries. Now, that is an assertion from me of fact, but how is the judge supposed to have made any finding to the contrary when he had no evidence on that question at all?
The evidence upon which he based that was a line of cross-examination.
But how would the witness know, unless he was an expert on trademarks? I mean, it's really a question of law more than the fact. I mean, you look at the registers, we have public registers of trademarks all around the world, and you can see that the trademarks are in different ownership.
But I beg to differ about it being a question of law. However, it's very hard to see how it's a question of fact before the judge. And it's it very hard to see how it could be decided on the basis of cross-examination of one witness. If they were cross-examining my lord, this matter is completely
Best of
unrivaled.
luck is all I can say.
That might have been the best thing to do, but they didn't call him, as I understand it.
No.
No. I mean, it's a strange thing because without getting it out of proportion, it seems to me at least obvious that there must be situations like the current situation which happen, even if not every day, and may happen in important jurisdictions, as it has here. Obviously, as between the US and Europe, these overlaps are absolutely critical. So you may get some way, Mr. Edinburgh, in persuading me this is an important case.
Well, my lord, I'm really most grateful for that because I wasn't...
Against my better judgment, obviously.
Obviously, I won't hold it against you, my lord. But the point being is that this case has bristled with so many different points. This point about whether or not it was common or not for the same trademark to be in different ownership was a minor point.
Yes.
That's
and
fine.
in fact, in a sense, it doesn't matter once one determines one has to decide it.
Yes.
Yeah. Okay, well, we can move on. But anyway, it's interesting.
Yes. So where I was when this started was the Argos point.
Yes.
And the
Whose
point...
judgment are we looking at?
Justice Floyd.
Yes.
Yeah.
You can see that on page 328, my lord.
Yeah.
And presumably we need to read all of 48 through to 53. It's a convenient thing for us to do, to just read those passages.
If I heard you correctly, my lord, yes. Yes, there's a couple of cases here, Merck as well, where we've sidelined, I'm afraid, quite a lot. I wasn't going to take it through paragraph by paragraph.
No,
But
we have looked at it, well, at least
Yeah.
I have. But we'll just do what my lord suggested quickly. And you say any of that is wrong? You can't really.
well, I'm in difficulties, but no.
So it's binding.
Yeah, exactly.
I know it's binding, but you have told us that the word targeting is misleading.
Well, sorry, yes, I mean, we say that the use of the word targeting is misleading because it leads people to go down a rabbit hole. The rabbit hole being, in essence, the one in which the judge fell, that he said that, and I quote, imports the notion of taking deliberate aim at something and is quite specific. It's so closely connected to the territory.
So you query the words taking a deliberate aim
It's too
because
narrow.
that's subjective, not objective.
Well, that's part of the problem, but yes, but it's too narrow. It in essence raises the hurdle for what is characterized as targeting to too high a level. What I say the relevant test is use in the jurisdiction. And we started off that point by saying it's a jurisdictional requirement. And it's a jurisdictional requirement so as to make sure that those people who do not trade in your jurisdiction are not caught. And that addresses the point of mere accessibility. The whole point is doing business in the jurisdiction. And to address the point Your Lordship, the Master of the Rolls has just raised with me, the subjective intention is relevant.
Evidently.
It only says, and he tells you how, doesn't he? In fact, paragraph
51, my lord.
51, yes.
I'm not trying to get out of that.
Yeah. But I still don't completely get why targeting as a word. I mean, I can see that taking deliberate aim is something different from targeting. But why targeting is in any sense misleading? Because you say it's a totally subjective word?
No, my lord, that's part of the problem. But part of the problem...
I seem to only get part of the problem.
Sorry, my lord, it's my fault. The problem is, we say it just elevates the requirement to too high a play.
But I mean, it's made clear it's not actually a requirement.
Sorry, my lord.
It's made clear that it's not a doctrine or, in fact, a requirement at all. I mean, he says it's a jurisdictional requirement.
Yes. Well,
so, I mean, so targeting is not an independent doctrine of trademark law. It is, in essence, a jurisdictional requirement. So, I suppose we're bound by that. Because trademarks are territorial in effect, those who are doing business outside the United Kingdom should not have their dealings subject to trademark law of the United Kingdom. It must be exclusively. Okay, well anyway, maybe just all terminological and a bit of a how many angels can stand on the point of a needle question.
Well, in my submission, it's not quite that. If I may take you to the...
Just before you move on, can I just ask you a question about paragraph 52, which I think is of some importance.
Lord.
So there, Lord Justice Foyd says, right at the bottom of page 340 in the bundle, in each case, it will be necessary to look at the acts which are asserted to be use of the trademark and to focus on whether those acts have targeted the United Kingdom. So it goes back to the point you were making earlier. It's act by act.
Yes.
So in the present case, we need to consider at least the following. First of all, advertisement. Secondly, offer for sale, broadly understood, as you submitted earlier. Thirdly, putting on the market. Lastly, importation. There you've got 4 different classes of act, and you might reach different answers in respect of those. So
yes,
you might say that there's no targeting at the advertising level, but still reach the conclusion that there's targeting when you get down to the level of putting on the market, for example.
my lord, yes, and that was exactly your conclusion in the Wharton case that you brought to Council's attention, paragraph 165, if I remember correctly.
Yeah.
But sorry, maybe I've got hold of the wrong end of the stick. I understood this analysis of the concept of targeting, particularly what Lord Justice Kitchen said, set out in paragraph 50, as relating to advertisement of goods. I mean, the concept of targeting relates to advertisement, doesn't it? Or does it go, or is it... there are a number of concepts floating around here. As I understand it, use in the course of trade in relation to goods or services in the UK is the test. And targeting helps you answer that test or address that test in the context of advertising on a website. Are you saying that targeting is also a tool that's used, or an independent test that's used in relation to other aspects of use of a trademark in the course of trade? Use of the sign in the course of trade?
The term targeting is commonly used in the context of advertising an offer for sale.
Yep.
Because in some senses it fits most naturally in the English language usage in that way. However, the underlying fundamental point is use within the jurisdiction,
Yep.
which is the jurisdictional point. And that is expressed, for example, when you talk about putting on the market, sometimes with different words. So, for example, sometimes the phrase directed at is used. But it encapsulates exactly the same point, whether there is use within the jurisdiction. And the term targeting has been used freely and not often precisely to sometimes cover up the underlying jurisdictional requirement. It's because it's an easy word to use that shortens all the sentences. Does that answer my lordship's question?
Sort of. I mean, I was trying. We'll come on to it, doubtless, but a sale can take place and can involve the use of a sign in the course of trade, I would have thought.
Yes.
Without it necessarily being targeted. Or
Well,
is that not? Are you saying that one inevitably goes with the other? I mean, I don't want to get sort of sidetracked into
no, it's all right.
a great examination of the concept of targeting, if in fact you're saying to us the real test is a different test altogether.
The test is use in the relevant jurisdiction. Commonly, when you're talking about adverts and offering for sale, the word target is
Understand
used.
with adverts.
But, for example, in the Blondquist case, which we're going to touch upon in the second ground, the relevant link between the alleged act and the jurisdiction was the fact that the alleged act, which was a sale in that case, putting on the market, was directed to a member of the EU. That was the link that allows the EU to exert jurisdiction over the allegedly infringing act.
So, bringing us back to the present case, can you help me on this? At trial, was it in dispute, subject to the Blondquist point, which might be a different question, that there was targeting once you got down to the level of the sales coming into the EU?
It was said that the sales occurred in the US, and so therefore there was no relevant use with respect to the act of sale within the jurisdiction.
They said the sale was completed in the US.
My lord, yes. So,
What about importation?
well, importation went down the rabbit hole of the fact that there was a focus upon the personal nature of the customer. And there was a long debate, in essence, about use in the course of trade with respect to the customer. And one examined all the Phillips type questions, which were goods in transit, counterfeit goods in transit. We say that's all just went down the wrong path.
Because the consignor was guilty of importing under the sign.
Basically, yes. Because you can have an act that is a single event concerning a single item. There's no need for a container load of goods.
Well, I understand that. And I wanted just to come back to the debate you were having with my lords. My Lord Justice Arnold explained, and I think you agreed, that it's clear that for an infringement of a trademark, it must be looked at act by act to determine whether there is use within the jurisdiction. And it is possible, is it, to have a situation where you don't use within the jurisdiction by advertising on an international website, but you do use within the jurisdiction by offering for sale on that website, or by putting on the market on that website, or by importation after a sale from that website. So the point that my lord was making is, it is not axiomatic that if you look at it use by use, you'll get the same answer to the four separate questions.
Well, in fact, even though I hesitate to put words in my Lord Justice Arnold's mouth, I mean, it's almost the opposite. You could get different answers.
I mean, that's what I've just...
Yeah, yes, yeah, exactly. It's
The
perfectly
answer to
possible.
my question could be yes.
Yeah, my lord.
Okay, good. I understand it now.
My lord, I was then going to move to the Advocate General's opinion in Coty, which you'll find behind tab 9, and in particular paragraph 39, which is on page 306. And this is taken as in essence to the next step. So we've seen that the use is a jurisdictional question. And in paragraph 39, you can see sign will not be so used within the meaning of Article 9.2, where the third party simply provides a technical solution necessary to enable a sign to be used, or engages in passive behaviour without any direct or indirect control over the act constituting the use. And then the reference is 26, which is the Daimler case. The point there that you take is that if you have a direct or indirect control over the act constituting the allegedly infringing use, then that's an indicator that you have relevant use so as to assert jurisdiction. And in 43, this is developed, for example, again, the last sentence, for that to be the case, the provision of their services would have to entail active behaviour and direct or indirect control over the act constituting the use. And again, it's a reference to Daimler. So the use has to be active, and it's use over which you have direct or indirect control by the alleged infringer, as opposed to being some sort of passive bystander. And this is all designed to exclude from the reach of a trademark proprietor, in essence, that use which is merely that merely occurs by reason of mere accessibility. And then if you go to the Merck case, which is behind tab 8, start and on page 261 of the bundle, the section on targeting starts at paragraph 153. But if you look at paragraph 155, I might read it out. Court held that in order for Article 15 to be applicable, the trader must have manifested its intention to establish commercial relations with consumers from the member state of that consumer's domicile. Clear expressions of an intention to solicit custom from that member state's customers, such as mentioning that it is offering goods or services in that member state. And it goes on to say the national court must ascertain from the website of the trader or intermediary and the trader's overall activity whether it envisages doing business with such customers. So this all turns back to the touchstone of doing business with people within the relevant jurisdiction. And then skipping to the end of the part that's relevant in Merck, from paragraphs 167 onwards on page 266. First, in determining whether an advertisement of goods bearing a trademark on the website of a foreign trader constitutes use of the trademark in the UK, it is necessary...
Well, that was the passage we just read in Argos, isn't it?
Yes, but sorry, it was in the context of the summary that's being put forward.
Well,
sorry, my lord.
Justice Floyd quoted this entire passage.
But I was going to touch upon the fact that the third criteria is the objectivity from the perspective of the average consumer, which is over the page on page 267.
Yes, there seems to be a deal of confusion at this point. Can I suggest to you an answer and see your reaction? You have to view matters objectively from the perspective of the average consumer. But that does not mean that you're looking for things that are known to the average consumer, not least because the average consumer is simply an aggregate of its statistical distribution. The point of viewing it from the perspective of the average consumer, who is deemed to be reasonably well informed and reasonably circumspect, is you're excluding the extremes of the distribution. So it's a normative exercise, but it's not about what the average consumer knows or doesn't know in terms of the statistics of the trade. It's merely a perspective from which you look at matters. Now, what's your reaction to that?
I'm happy to adopt that, Lord, because you then see, in essence, what strikes such a person. And at this stage, I was going to actually take you to some of the actual evidence, so you can see how the average consumer would perceive the website. This is in the supplementary bundle.
But is this not about advertisement?
Well, it often is about advertisement, yes.
I thought advertisements that on an international website, advertising goods on an international website by itself was not use of the trademark in the relevant territory.
Well, it might be, my lord, if those advertisements are in essence conducted such that they elicit business.
Right, so you challenge the finding here that it was not. You say this, despite the Merck and the targeting, the decisions you've taken us to, you say this is such a heinous use by advertising in the relevant jurisdiction that it is an infringement in itself.
Yes. And to put that submission in context, if you go to the supplementary bundle, tab 1, little tab B, this is the Amazon...
Could you try using pages?
So sorry, page 30, page 9, my lord. This is an example of the Amazon global business model. You can readily ascertain that because both top and bottom lines show that it's the amazon.co.uk site. And so there's no question here that
Yes,
these...
so this was admitted.
That's right, that's what I was just about to say, my lord. There's no question here that these are advertisements that use the sign in the jurisdiction because it's admitted.
Yep, and further than that, this was the subject of the admission on the 30th of November. This was infringement.
Yes.
Yep.
But I'll start in there on the grounds that it's a firm foundation, my lord.
Right, understood. Thank you.
Sorry, I must be looking at the wrong page. Is it
Page 9, my lord.
page 9 at the bottom of the paper copy or page 9 in electronic?
It should be page 9 electronic.
It's what I've got is a sort of notice.
Well, my lord, there are 3 numbers on the page. The number in the furthest bottom right is
The
9.
box is short. Okay, that's page 10. Yeah. Okay. And this is amazon.co.uk, but it says amazon.com selections at the top. Is that the point?
Well, no, the point I was making was actually simpler because this is an admitted act of advertisement that is used within the UK. I was starting from where
I see, this is UK.
Yes. See, what happens with respect to this business model is that the .co.uk site links through to the .com site.
Yeah, so hence we see 1 to 16 to 32 results for Amazon.com selections.
Yeah.
And then the search term, Beverly Hills Polo.
Yeah. And pricing in pound sterling. And the involvement of D2 is clearly shown on page 16. I think it's page 16, my lord, but there might be...
It says sold by Amazon US at the top.
Correct, my lord, with 3 boxer shorts.
Yeah.
And then there's script at the bottom. And in the 3rd paragraph from the bottom, this order contains 1 or more items sold by Amazon Export Sales LLC, Amazon US. That's D2.
Mm-hmm.
And so moving from that foundation, which in essence formed the subject matter of the mission on the 30th of November, if we then go to the Amazon export model, which commences on page 93, behind tab 1D. So what we have here is, this is where a person from the UK, but viewing directly the .com site, will alight. You can see it's the .com site from the very first line at the very top. And then top left-hand corner, the potential customer will see deliver to United Kingdom. And then in the text that's below the first graphic, so below the picture of the aeroplane, it reads, you are on Amazon.com. You can also shop on Amazon UK for millions of products with fast local delivery. And we would say that the way in which the average consumer would perceive this is that what that is saying is that this site is intending to do business with you, but you can also do business with these people on Amazon UK, and you're not excluded from doing business here.
Well, presumably the wording to the right of the aeroplane graphic, in fact the graphic to the right of the aeroplane graphic showing a map of the world, and we ship over 45 million products around the world, certainly indicates it's not limited to people in the US.
Exactly so, my lord. And we say that your lordship's point is strengthened if you go to page 96, where halfway down it says you can shop in 8 languages.
Well, that might be. They might have 8 languages in America.
That is true, my lord, but...
The next one may be better, shopping at 60 plus currencies.
Yes.
I mean, you get that on page 93 as it happens. I don't think we need to go to 96 for that.
Oh, yes. Then if you go to page 99, what's happened here is that somebody in essence has clicked on the little icon to which I drew your lordship's attention to start with, deliver to UK, and so it's expanded. We ship internationally. We're showing you items that ship to the United Kingdom in bold. To see items that ship to a different country, change your delivery address. additional languages and currency settings are available. So a person reading that, we would say, takes away the impression that this website is intending to do business with them. That's,
Click here to shop in your local currency.
and those currencies include pounds sterling and euros. Again, this is reinforced on page 116, right-hand column. This item ships to the UK. There's a little twist here. This is showing the Cinch Boys big long sleeve printed t-shirt. You'll have seen from the judgment that because of certain restrictions were entered, there had to be dummy sales, so to speak. And so, in essence, you read this for the allegedly infringing sign.
Sorry, I can't find this item ships to the UK.
Top right-hand corner, my lord, under the first top banner. It's in quite small writing. Have you got the photograph? Might I just hold it up?
It's just under the price of $34.26.
Yeah, my lord.
Yeah, got it. Thank you.
So, as I understand it, we imagine that on this page we had the
Beverly Hills polo shirt, my lord.
yeah, by way of example.
Yes, my lord.
Yeah.
And so, assuming it's a Beverly Hills polo shirt, we would say that this is an advert, that a person looking at this page would understand to be put forward such that they should enter into a business transaction with those who are operating the website. So, to come back to my Lord Justice Arnold's point about act, this isn't advertising, an offering for sale or an exposure for sale. The last wording is the UK word.
Do we have a page that shows what you see when you add it to your cart and what happens when you buy?
We do. So say, for example, you go to page 123.
Yep.
I think that's exactly the same item.
Yeah.
I think it is, yes.
Shipping address Peter Elkin, Open Viaduct. Yep.
Yeah.
Place your order in GBP.
And you can see the pricing is now in pounds on the right-hand side, my lord.
Yep. You see, it's a neat illustration of why you need to look at it act by act, because at page 116, the pricing is in dollars.
Yes.
Whereas when we get to 123, the UK consumer, having put it into his cart, he's invited to place his order in GBP.
My lord, yes.
So I would assume that your submission is that even if, contrary to your submission, 116 is not an advertisement aimed at the UK, or targets the UK, and I know you don't like those expressions, but for convenience, you would say, in any event, 123 is plainly an offer for sale to the UK.
My lord, yes.
What did the judge say about that?
Well, he didn't really, my lord. This is one of the problems. We say that he didn't grapple with this particular point.
Well, what did he say about your submission, that you had to look at it act by act?
Well, again, he didn't approach his analysis in that way. His point was, in brief, that a person arriving upon the .com site would see that it's an American site and therefore not intended for them, that is a UK EU consumer.
Well, I mean, it may not have been primarily intended for them, but if you're right, it's undoubtedly intended for them in the sense that you can buy quite happily from it.
That's exactly my point, my lord.
I mean, all of us, even elderly judges, have been on foreign websites and bought goods that were primarily in a foreign currency when we wanted something not available elsewhere. I mean, that's just something people do occasionally, not every day, but sometimes.
But there may be an occasion when a person has arrived upon a site, they've looked it up and they've searched everywhere for it.
Yes.
Because it has something.
Yes, that they didn't have elsewhere.
That's right. But they're all hurdles everywhere, and you're getting it despite those hurdles.
But are you saying that if there are hurdles, that the hurdles can prevent it being use by an offer for sale if you have to go over hurdles? Because that seems slightly counterintuitive. My lord's point is, well, you've now got through these hurdles, if there were hurdles, by clicking a number of buttons to change it to pounds and clicking a number of buttons to change it into whatever language you speak. But ultimately, they'll sell it to you. Surely, once you get to the stage of getting over those hurdles, however high, it's used by offer for sale.
But that's exactly the point, my lord. It's going down to the analysis of which act you're looking at. Because in the example your lordship has just given, the advertisement may well not be use in the relevant jurisdiction.
No.
Because there was no intention with respect to the advertisement page to transact with a customer within the relevant jurisdiction. But if you fight your way through everything such that you then get to an offer, because my Lord Justice Arnold was drawing the distinction between pages 116 and 123, if I understood correctly.
It did. And focusing on the present case, as I understand it, and tell me if I've got the wrong end of the stick, it's at 123 that the restrictions bite. Because now, the reason why we have this dummy transaction is that because of the 2019 restrictions that were put in place by Amazon, when you try to do the 123 page with the Beverly Hills merchandise, you will be told at that point, we don't ship this to the UK.
Yes, the precise details of when the restrictions kick in actually varies a little bit. But it's broadly at this stage, yes.
Right, yeah.
So the long and short of it is, excuse me, the long and short of it is that you can't ship to the UK or the EU. But some of the precursor steps you can still do.
Well, is that an offer for sale if you then say, I'm not actually going to sell it to you?
Well, the point is, my lord, is that an offer for sale might still be an infringing act, regardless of what happens down the line.
That's what I've just asked you.
Yes, I say it is still potentially an infringing act. You need to look at, you can have in one commercial transaction a number of different infringing acts.
So you say, I mean, to put it in simple language, you say it is an act, it is an act of making an offer for sale, even if, because by the time you click the relevant buttons, you get an offer for sale to sell at $38.85 this product under the signs to the customer in the UK. But when he says, or she says, yes, a big sign comes up saying we don't sell to the UK, and that's too late. The infringement has occurred.
Basically, my lord, yes.
Right.
And the defendants took a point there. That was where this invitation to treat point turned up, because they said that this was not an invitation to treat.
But an offer for sale is a very simple language. I mean, if you this page, if it's I was going to say, if it's not an offer for sale,
What
I'd
is
like
it?
to know what it is. Well, I was going to say I'm a Dutchman, but I am actually. So, long time ago.
My lord, that was part of my point in the opening. I said offer for sale is a European concept, and we say it would be wide enough to include this.
Yeah.
If I'm wrong on that, it doesn't matter, because it would be another non-expressly listed infringing act.
I mean, you say, I suppose, do you, that the judge placed too much emphasis on the ramifications of a finding that you were right, and not enough emphasis on the language of the legislation and effectively the law.
My lord, yes.
But can I have your submission on where we seem to have ended up as a result of the restrictions? And I take your point that you say, well, it's not legally binding, but let's leave that aside just for the moment. So suppose we end up in a place whereby page 116 is not an infringement, it's an advertisement which is insufficiently targeted at the UK. But 123, which is what is prevented by the restrictions, if it were not prevented, would be an infringement. Now, I appreciate you're arguing your primary target is 116.
Understand.
But I mean, as a matter of an outcome, why is that not a reasonable outcome?
The reason we would say that 123 still an allegedly infringing act that we could stop is because it falls within.
Yes, but
sorry.
What I'm suggesting to you is that you would be right on 123.
Yes.
So that would be an infringement.
Yes.
It doesn't now happen because of the restrictions.
Yes.
So it's passed only, subject to the question of whether there's any threat to do it again. But 116 is not an infringement even in the past. So one draws the line at that point. And what I'm asking for your submission on is, why would that be an incorrect place at which to draw the line?
The reason we would say that is wrong is because the way in which you get to 116 is in the context of looking at going through the other pages. And the other pages are that there's delivery to the UK, so therefore it's clear that the average person would think that the operator of the website intends to do business with them, and it's just at that stage that they haven't converted things into pounds. That can be done at an early stage or a later stage. When you log on to these things, they store some of your data. And it might be that your preferred currency is euros, for example.
I understand the point. You say it's sufficiently clear, objectively assessed, that this website is doing business with the UK. But the problem is it's 45 million items. So the mere fact that it has a generality, the website may do business with the UK, is that enough? If when you come to put the item in your cart, you're then told this one does not ship to the UK.
Well, when you come to put it in the cart, you're not told why you can't.
Why does that matter?
Because you are still left with the impression that you can do business, and the intention was to do business with you.
So it's still an offer for sale
Yes.
until you get to the stage where you actually say you want to buy, when they tell you can't. So you say, my lord's attempt to draw the line is too late, because in effect there has been an offer for sale before the axe comes down. I mean, the axe could come down with any customer who had said they wanted to look at it in pounds and had said their address was in England, and you would then, when you tried to put it in your cart, you would be told you couldn't, and you'd say, well, that's okay if my lord is right that the advertisement is not covered.
Yes, my lord. I mean,
and that would be, that at least you'd accept would be a reasonable place to draw the line if there was a machinery like that. Or it would be a better place to draw the line.
not sure I've.
Not sure it matters.
Yeah. You see, part of the problem is, and this goes back to one of the myths, and that is, you're not told, the consumer is not told that actually there is no intention to do business with you. It's just you can't complete the putting on the market and the importation parts.
I mean, as I understand it, you say there's no difference between 116 and 123, because if you look at them, at 1.2, apart from currency, and you can shop in whatever currency you want to, apart from currency, 116 tells you how much it will cost to ship this item to the United Kingdom. It tells you this item ships to the United Kingdom. It tells you when you can get it. And you say that's specific. I mean, that's tailored to, although you talked about fighting your way through earlier, you say actually this is tailored to somebody who is trying to buy this item in the United Kingdom.
Yes.
He's told how much it's going to cost him, whether he wants to pay in dollars or pounds, that's up to him. He's told how much it's going to cost to get it through customs, sorry, for shipping, sorry. And he's told that he can choose a date for delivery, which in fact he gets given options for at page 223. And you say that is, it's actually tailored to somebody who wants to buy this particular item for delivery on a certain day in the UK.
My lord, yes.
Right. And you're saying he should be told, actually, before he gets through that, actually you just can't.
Yes. To go back on one very small point, you quoted back at me the phrase about fighting your way through. That was only in the hypothetical scenario that the advert was not relevant use, because I was trying to draw the distinction that it's possible that the advertisement is not relevant use, but a later part of the commercial transaction might be. The reason is that marries up with the facts of Walton,
Okay.
to which we'll come to later. My lords, I was then going to move this to the example of fulfilled by merchant, and you'll find that behind tab 1C, starting at page 21. Now, this is the scenario that involves Amazon the least. And so on page 21, you still get in the top left-hand corner, delivered to the United Kingdom. You still get, you're on Amazon.com, you can also shop on Amazon UK. So again, it's perfectly clear that you can shop here, you can do business here.
When it says we ship over 45 million products around the world, I don't suppose anybody knows whether that's Amazon.com exporting 45 million products from the US website, or whether that includes all the local websites.
I do not know the answer to your lordship's question, I'm sorry. Oh, sorry, that was all I wanted to show you on that at this moment. I was going to come back to this later with respect to the involvement of D3, but...
Well, do we have a sample transaction for this one?
My Lord, yes, we do. For example, if you go to page 54...
Right. Well, that's at the stage of putting it in your card.
Yeah.
Do we have the page that corresponds to 116?
Just one second. Yes, page 45, my Lord.
Thank you.
I think the previous page, the previous step is page 40. It all works through pretty much in order, if you see what I mean. And so on page 30, for example, you get the ship to the UK points as well. And so, my Lord, the judge, in essence, dismissed the point that the whole transactional process was designed to be smooth and as relatively painless as possible. But we say...
Which paragraph was that?
Sorry. My Lord, can I come back to you with respect to that precise paragraph? I think it's about 167. But...
I mean, he says 171. My judgment is plain that both Amazon.com and BHPC listings on it are not targeted at the UK EU consumer, and they know full well they're viewing or shopping on the Amazon website primarily directed at US consumers. Claimants submitted it's irrelevant. In my view, it's highly relevant if the average UK consumer believes that Amazon.com is targeted at US consumers, not them. They appreciated the disadvantages, largely irrelevant, that Amazon thereafter makes the process as plainly and easily as possible. I mean, you say it's not just that they make it easy, they allow it to happen.
Yes, it's absolutely, objectively, that a consumer thinks, I'm welcome here. They're expressly saying we ship to the UK. They are looking after my concerns in the sense that I can shop in UK pounds, sterling. If I were a member of the European Union, of course this is also an EU case, I can convert the language to, and we had evidence on this, that there was Spanish available. That's of course not a language that's spoken exclusively in the EU, but German was also spoken. and that's far more closely tied to the EU. You've given delivery dates. Now, there was evidence that the delivery dates were slower coming from .com than from .co.uk. But in my submission, those points about slower delivery dates or higher costs arise much further down the line.
I mean, he gets involved in the following paragraphs with the concept of whether the Amazon website as a whole is targeting the UK as opposed to the agreed issue, namely whether the individual offer relating to the claimant's products were targeted at the UK. But you say that rather misses the point.
Yes, because you remember one of the pages I showed you said we're showing you items that ship to the UK. And so therefore, what you're seeing is in the context of that up front. Now, indisputably, some things on the entirety of the .com site could not be shipped to the UK. Pharmaceuticals are a likely candidate for that.
Mm. And then he comes to what Mr. Haddad was concerned about, but in a way that's also relevant.
Yes, my lord, exactly.
I mean, however badly he may have seen Mr. Haddad and his evidence, that's really got nothing to do with the objective question of whether there has been use by advertisement, use by offer for sale, use by importation in the UK.
Exactly, my lord.
And you say really, perhaps the nub of it is the application at the beginning of paragraph 174. As I said above, targeting imports the notion of taking deliberate aim at the consumers in another country, which is putting them, you say, putting the matter rather too high. The question is only whether there's been use by making an offer for sale or use by advertisement, etc.
My lord, yes. And my
So
lord,
that's why you said targeting is not a helpful word, because targeting seems to imply a subjective intention and nothing but a subjective intention.
yes.
You know, I target you if I point my gun at you. If I just wave the gun round the room and shoot and I hit you, I haven't targeted you. I've killed you, maybe.
Yes, but it's the difference between murder and manslaughter. The mens rea
You'd
point.
have to explain that. Yeah. Anyway, maybe not a helpful analogy.
No, but my lord, there was another point that your lordship touched upon in paragraph 171, which is despite all those disadvantages, the disadvantages to which the judge was alluding were longer delivery time and higher costs. But the point is those come down, those are downstream, so there's no causative effect in some senses. They only discover that after the advertisement, after the offer.
I mean, just dealing with the practicalities of this, let's say you're right about all this, and this is an infringement. What's the effect for a business like Amazon? I mean, Amazon then has to investigate where trademarks are held and has to import restrictions, I mean, it has, before it starts, it has to go through all its 45 million listings, work out where there's rights holders outside the US, and impose restrictions at the earliest possible stage, effectively. I mean, depending on whether you're right about advertisement.
Well, the first point is, indisputably, there would be consequences.
Yes.
The second point is that one of the problems in this case is that there were mechanisms whereby a concerned trademark proprietor could report matters to Amazon such that Amazon could then try and rectify or at least address the concerns. But the problem with that reporting mechanism was that you could only refer your concerns, or your concerns were only noticed, if you were the owner of the rights in that jurisdiction to which you refer the complaint.
Yeah, well, I mean, let's assume, I mean, the mechanisms are not my overwhelming concern. My overwhelming concern is it possible for an international trader, and I hear what you say about whether they're truly international or not, but a global trader like Amazon to continue to trade from a website that is accessible from many, many countries, if you're right? And the answer you say is yes, they've just got to put in place different and more sophisticated precautions.
In short, my lord, yes.
And that's exactly what happened in the L'Oreal and eBay litigation, where I referred the questions to the Court of Justice. It never came back after the Court of Justice's judgment because the parties then proceeded to negotiate an agreement in the light of the Court of Justice's answer and the other worldwide proceedings. And ultimately, a modus vivendi was reached whereby eBay put in place additional restrictions.
My lord, yes. Long and short of it. We say this will alter the way in which Amazon does business. We don't shy from that.
Yeah.
But we say that it's perfectly appropriate for its way of doing business to be restricted because at the moment it's acting in a way that trespasses upon local trademark rights. And at the moment it's riding roughshod over that, we would say.
Well, not quite roughshod, but you say infringing. I mean, I take these things fairly,
my lord, yes.
in a fairly binary way, infringing or they're not infringing.
Well,
if
we
they're
say
infringing, then they're not allowed to do that. I mean, trademarks are actually a rather binary exercise.
yes, my lord. I mean, it's the way of intellectual
You
property.
can't infringe a little bit.
No, well, that's exactly the point I made earlier, that a single act with respect to a single item, to a single person, is an infringement. You don't need a container load of goods before you cross the threshold.
No. I mean, I completely get that.
Yeah.
It's a statutory cause of action. Yeah.
When you said earlier that there were maybe restrictions in relation to pharmaceutical products and things like that, is that as far as you know, or was there any evidence about whether it's feasible to put restrictions on individual items other than by category?
My lord, the first point is that submission was made on the fly, so I have no evidence with respect to it in particular. That's probably the fullest answer I can give. But there are ways in which you can block the sale of a certain type of goods, so opiates, for example, because those are prescription drugs as opposed to over-the-counter drugs. I think they're prescription drugs pretty much
This would be
everywhere.
a much more granular exercise, if you're right,
Yes.
that Amazon would be required to do, because
Yes.
it would be good by good by good, territory by territory by territory.
There's a mark by mark, but territory by territory, yes. Actually, having said that, it might relate to goods only in certain aspects because not all trademarks are registered in respect of all the goods upon which they're used.
No.
Yeah, but then you're getting into unregistered rights, which I don't.
Yeah.
I think this case is complicated enough
Yeah.
without getting into that.
I thought it was simple. But you told me.
Milo, do you mind if I quickly read my notes?
No, sir, you carry on.
Thank you. My lords, we've touched upon the way in which an average consumer would view the matter objectively, but I don't wish it to be understood that my submissions do not include the subjective element, because it's clear from the jurisprudence that the subjective element does play a part.
Well, it's of evidential relevance. It's not the test. The test is objective.
Yeah.
But the subjective intention of the vendor may be of evidential relevance.
My lord.
I mean, where does the subjective element get you in this case?
Well, to the extent that it is clear that coding has been implemented to allow you to, for example, select GB, pounds, things like that, the language. That all requires...
That all comes into the objective analysis, doesn't it?
It depends how you wish to look at it, in the sense that, I mean, objectively that's how it's viewed, but it also must have arisen by a subjective decision.
Well, it's a deliberate act on the part of Amazon. Does it go any further than
No,
that?
but that's as far as I want it to go. It is a deliberate act. Because that was the case.
It's not an accident that they accept payment in pounds.
My lord, yes. I mean,
but does it go any further than that?
That just goes back to the quotes that I gave you from the Coty judgment in paragraphs 39 and 44 of the Advocate General's opinion. So it's an active act over which they have indirect or direct control. There's another point here, and that is that broadly, with respect to trademarks, objectivity is the way forward, because of course you can't have, well, rather the opposite, you can innocently infringe a trademark. And so therefore, the subjective element of the alleged wrongdoer falls to one side. My lords, I've got a note on this point about whether individual pages or the whole site is responsible. And I think we've already touched upon that, but if there's any questions from your lordships.
Well, I think what would assist us is how far you're going on that. I mean, we've established, I think, your case is that not really page 123, to take the first example we looked at, but page 116 is an infringement. But would you say that the very first page is an infringement? Can't be, can it? Because it's not even got the trademark on it.
No, my lord is right. Whoops. That page does not commit any acts that fall within the prohibition, but it is relevant because it sets the scene for pages that do commit relevant acts.
To be sure, of course, you get to the subsequent pages by starting at the home page, for sure. But does that matter? Because it was never your case that the entirety of the Amazon.com website infringed.
No, exactly so. But the reason I'm sort of pulling back a little bit is I say you need to read, for example, page 116 in the light of the information that you have gathered from the first page. Because you see that in the light of delivered to the United Kingdom. So that page itself, as your lordship has pointed out, contains, well, it doesn't contain any use of the sign anywhere.
No.
So the page itself must be unobjectionable. But the pages that are objectionable need to be read in the light of the information of that page. That's as far as I'm going, my lord.
You don't have to go through page 96 to get to page 116, do you? Can't you log on just straight on to 116 if you get your search right? I mean, you present it as if we have to go through the gateway of 96 to get to 116. But I don't know, I'm just doing this from memory, but I seem to remember if you, depending on getting your Google search right, you could actually just go straight on
My Lord,
to
I
the
think
product,
you
can't you?
might, I don't know the answer. I think your Lordship might be right, but you would, this was done from a sort of perspective of somebody who's just approaching it generally. So that's why we're taking you through every step.
No, I understand if you go onto just the home page and
Yeah.
then you select a category and then you know, product and then you select et cetera, you go through the process
Yes.
you've shown us. All I'm saying is your proposition that you have to read 116 by reference to 96 assumes that you will have seen 96 before you see 116, and I'm just questioning whether that's in fact right.
I wasn't going that far, my Lord, sorry. What I was saying was that if you've arrived at 116, having gone via the first page, then you read it in the light of that.
Yeah.
But if your Lordship has entered all the relevant search parameters in a search engine such that you then alight upon 116 directly, obviously the other pages you've never seen, but you still have...
One of the problems with that, which I think is possible, I will be corrected, somebody will correct me, I may even be misremembering, but if you do go to 116 direct, you won't have actually gone through a page which invites you to click to go to amazon.co.uk.
That might be right. I'm sorry, my Lord, I don't know the answer to that question.
Okay.
What I can say is, of course, on 116 you still have in the top left-hand corner delivered to the UK, but that's also just reiterated by the verbiage on the right-hand side.
Yeah.
There might be a problem, sorry. You might not be able to get to this page without having logged in.
116 says at the top, hello, sign in. So that suggests that the user has not logged in.
I just have a vague recollection of having landed on pages and realised I was on the US site when I've been doing my own shopping online, because I happened to then see the price advertised in dollars and realised I'd landed on the page wrongly. That's the only point I was making. It just goes back to your... Anyway, there we go. There's no evidence. I mean, the reality, there's no evidence about it one way or the other to answer that question.
No, my Lord.
Okay, we probably ought to make a bit more progress, Mr. Eden.
You'll be pleased to know that the other grounds are shorter, my Lord. Because I think we've covered a lot of general points here, and so therefore we can take them in some senses more quickly.
You've had a talkative bench.
My Lord, that's never concerned me.
Probably never not happened here.
My Lords, I showed you that the involvement of D2, and one of the points about D2, of course, is its very name, that it's Amazon Exports Limited. Again, that's just another indicator that it's dealing with things that are destined to leave the US. And there's a small point in the supplementary bundle behind tab C on page 83. This is to do with the fulfilled by merchant transaction, and this is actually a shipping receipt. And the second line from the very bottom, it says in bold, please note, and then it says, this is not a VAT invoice. And that actually indicates that it's UK-centric, because value-added tax is a European tax, but in the rest of Europe it doesn't go under the initials VAT. For example, it goes under the initials IVA in Spain.
or TVA in France.
My lord.
Yeah.
My lord, that brings me to the end of ground one, subject to any further questions that your lordship might have on that particular issue.
What's the test we have to apply? Is it that no reasonable judge could have come to the conclusion the judge came to, or is it just that we don't come to the same conclusion? What's the relevant approach?
I can just give you the wording. It's CPR 5221, paragraph 3A. The appeal court will allow an appeal where the decision of the lower court was A, wrong.
Yeah, but
Sorry.
I know, but as I understand it, this is a question which has a number of factors which have to be considered to come to an answer.
Well, in my submission, on this point, the judge was wrong on his application of the law because he did not interpret the use of the word use correctly. He substituted his understanding of the word targeted and therefore erred in law. It's all law, this appeal. Does that address my lord's question?
Yeah.
I'm not trying to overturn any facts. My lords, then that goes to the second ground, which is the Blondquist case.
So, before we get into the detail of this, can I ask a preliminary question? Does the question on Blondquist arise if page 123 is an infringement? So just assume, for the sake of my question, that 116 is not an infringement, but 123 is.
Yes, it.
Does the Blondquist question arise?
The answer is yes.
Why?
Oh, well, sorry.
Because it adds nothing, even if you're right.
It does add something. My understanding was, my lord, that 123 was analysed as an offer.
Yes.
Then Blondquist goes to the next point, which is putting on the market.
Conceptually, of course, as you said earlier, it's act by act. So, of course, in theory, one can have a separate analysis. But why would it be of any point? Because if the offer for sale is an infringement, then why does it matter whether the subsequent sale is an infringement? Because it adds nothing.
Well, then the way in which I would put it is, if you're against me on 1, 2, 3.
Yeah, I'm asking you if we're in your favour. Obviously, if we decide that 1, 2, 3 is not an infringement, then the Blondquist question becomes highly pertinent.
Yeah, I mean, the way in which it was run was, in the claimant's view, Blondquist was absolutely clear. And so that was put fairly front and centre of the case. The judge found against us on that. We thought it was a straightforward point. We were wrong. We still think it's a straightforward point. And we still think it's an important point. Your lordship's point goes to, in essence, damages.
Yes.
It might not add to the damages, but it still goes to a different type of wrongdoing that we say is still pertinent. Now, we may not get any more damages as a result of it, but the point is that a different sort of wrongdoing could potentially be stopped. Does that address my lordship's point?
It does, thank you.
And with that, we move on to Blondquist. Now, long and short of this is, the judge didn't like the case. He said that there were no relevant facts and that it certainly didn't support the proposition that I was putting forward that it supported. But the first point is, it's an Article 267 reference. Such a reference cannot be made in a vacuum. It has to be made in a factual matrix. The second point is we say that the facts are readily ascertainable from the case. In fact, we say the facts are absolutely plain from the case. And you can see that by going to first of all, the Danish Supreme Court decision, which is behind tab 6, which starts at page 179.
Am I right in understanding that this is the subsequent decision?
That's right.
Do we have the referring decision?
No, my lord. Now, we say the essential facts can be readily ascertained from this. So, the first point in paragraph 7 is that it was undisputed.
Sorry, paragraph 7 of the judgment.
No, paragraph 7 of the Danish Supreme Court decision, which is page 184, sorry.
Yeah.
And if you start at the second sentence, the Supreme Court bases its decision on the fact Fashion Watch Online, based on an order from Mr. Blondquist, entered into a sales agreement concerning the watch at issue in the case and shipment of the watch to his address in Denmark, and that the firm executed the sale and the shipment. So we say from that it's clear that the sale was executed abroad. Second point is that it is undisputed that Mr. Blondquist brought the watch for personal use and that he did not infringe. And that's important because he himself did nothing wrong. It was whether or not the Fashion Watch Online firm did something wrong. And if you turn to paragraph 9, which is on page 185, this sets out the order in which things need to be looked at. So the Supreme Court finds that upon Fashion Watches Online's entering into the sales and shipment agreement with Mr. Blondquist, and upon executing the sale and shipment, if you skip a bit, a business use of Rolex's trademarks took place, which infringed Rolex's rights under the Trademarks Act. And so therefore, the first point is that there was an infringement of the Trademarks Act. And the question was whether or not there was particular business use. And that business use had to occur within the jurisdiction. And then you go on to see that at the time when the watch sold by Fashion Watch Online to Mr. Blondquist entered Danish territory, the respondents came under the protection ensured them under the regulation. That's the customs regulation. And so customs regulation can only be invoked once there is an infringement. And in this case, we're looking at a trademark infringement. And then if you go to the decision from the Court of Justice, which is behind the previous tab, tab 5, starts at page 165, but the operative part starts at page 176, paragraph 23. So, paragraph 23 is important because it says, as a preliminary point, it must be observed that, by its questions, the referring court seeks a clarification of the term distribution to the public within the meaning of the Copyright Directive and the term use in the course of trade within the Trademark Directive. So, the whole point of this case was whether there was relevant use in the course of trade. And so, therefore, whether there was any infringement of an intellectual property right. And if you have infringement of an IP right, you can then invoke, if you have a certain sort of infringement of an IP right, you can then invoke the customs regulation. Broadly, the customs regulation can only be invoked in cases of double identity. And so that's why double identity is important. And 25 says the customs regulation introduces no new criterion for the purposes of ascertaining the existence of an infringement of an IP right. And it refers Montex Holdings, paragraph 40. Such an infringement can therefore be relied on to justify action by the customs authority. Only if the sale of the goods concerned is liable to affect the rights conferred by the conditions laid down by the Trademark Directive.
Can you help me on this? We see repeated references here to the Community Trademark Regulation, as was now the EU Trademark Regulation. Whereas my understanding from the Danish Supreme Court is that they were relying purely on national rights. Have I misunderstood, or did the Court of Justice think there were CTMRs in issue as well?
My Lord, I don't have a direct answer for that question.
Actually, I've answered my own question. Sorry, there were CTMRs as well.
I thought there would be because it's Rolex.
Yeah. Okay, so that's why we get references to both. Yeah. Okay, thank you.
And also there's the copyright issue, which I keep skipping over because that involves something different. Because the Rolex watch was protected by a number of different rights.
Oh yes, and sorry, I was misquoting what the Danish Supreme Court said. They did refer to the EU TMR at paragraph 9. I'm sorry, I was wrong about that. Thank you.
Well, Lord, I was going to very quickly skip through this if I can. And so therefore, if you get to 29, accordingly, EU law requires that the sale be considered. So that's the act we're talking about. In the territory of a member state, that's the thing that gives you jurisdiction, to be a form of distribution to the public with the meaning of the Copyright Directive, or use in the course of trade within the meaning of the Trademark Directive. Such distribution to the public must be considered proven where a contract of sale and dispatch has been concluded. And what we say here is that if you look at 32, however, the court has held that the rights thus protected may be infringed where, even before their arrival in the territory covered by that production, goods coming from non-member states are the subject of a commercial act directed at the consumers in that territory, such as a sale, offer for sale, or advertising.
Now, I appreciate you don't like the term targeting, but as I understood your submissions earlier, you were saying that when we see the expression directed at, it's getting at the same underlying concept.
Yes, there's a number of different phrases. The key point is use in the jurisdiction, but because it's long and cumbersome, people are using shorter phrases, directed at, targeted at. But yes.
Yep.
But see, the point is that that's the touchstone. It's the commercial nature, the intended proactive commercial nature. Well, Lord, I'm conscious of time.
Yes, well, you've got 2 minutes left if you want it.
Right, in which case, 34, which is common ground that, in the case of the main proceedings, the goods at issue were the subject of a sale to a customer in the European Union. We say that's the touchstone, that's what links the Act to the EU and thereby allows the EU to take jurisdiction over the matter. And that the Act itself, the sale itself, was sufficient because in this case it was held that there was no need for there to have been any offer or advertisement targeted at the consumer in the EU. So this is a case where there's no targeting of adverts, no offer for sale targeted at the EU. The act, the wrongful act, is the sale, and what gives jurisdiction to the Dutch authorities is that that sale was
Danish,
to...
Danish authorities.
Sorry, my apologies.
Too many Dutch. What gives
Well,
jurisdiction
to
to the Danish authorities
was
is
the sale
the sale.
to the person resident within that jurisdiction.
Yeah. Okay.
I've rattled through that, but
Well, that's what you say, and you maybe show us why the judge was wrong at 2 o'clock. Perfect. Thank you very much. 2 o'clock.